Good afternoon, everyone. Welcome back. We're going to continue hearing evidence from Mr. Albon. Mr. Albon, can you see me and hear me clearly?
Yes, I can.
Thank you very much. Welcome back. Are you ready to continue, I hope?
Yes.
In that case, I shall invite Ms. Grange to put some more questions to you. Yes, Ms. Grange, when you're ready.
Yes, thank you. Yes, good afternoon, Mr. Albon. I now want to ask you about Kingspan, and in particular about the BBA's certification of the Kingspan Cool Firm K15 insulation product. And if we could go first to your third witness statement, that's the statement in which you deal with K15, at BBA 30100751, page 15, and paragraph 50. We can see that in the question, at question 10 in the middle of that page, you were asked by the inquiry about your knowledge of the BBA's relationship with Kingspan in October 2008. And you say, I was aware of Kingspan as a holder of a number of certificates, but as far as I can recall, up to October 2008, I had little, if any, direct contact with them, as I was then employed in other areas of the BBA's business. Now, can you help us? When was it after October 2008 that you did first have direct contact with Kingspan?
When I became technical manager in 2009, I had more involvement in the insulation sector than I had previously. I may at that point had some dealings with Kingspan. I became directly concerned with them when I became head of energy and ventilation, 2012, 2013, something like that.
Right, yes, thank you. And we'll come on to this in a little bit more detail, but when did you first become involved in any particular certificate for K15 in any capacity?
As far as I can recall, that would have been the second issue, I think, of their initial certificate.
Yes, was that the second issue published on the 17th of December 2013?
Yes.
Yes, thank you. So when you were technical manager between 2009 and 2013, were you responsible for the policies and procedures which applied to the K15 certificates?
Yes.
And when you were head of approvals for construction products, that's between 2013 and 2019, did the K15 certificates fall under your area of responsibility?
Yes.
Thank you. Now, prior to your own involvement, I think you're aware that there'd been two previous published BBA certificates for K15. Issue 1, dated the 27th of October 2008, and amended issue 1, bearing the date of 6th of April 2010, but which you tell us was not published until the 12th of July 2013. Is that correct?
Yes. I should perhaps say there is some uncertainty as to exactly when that was published. That's the best date that I can give you. It's not entirely clear.
I see. And when you say that's the best date I can give you, how have you ascertained that publication date of the 12th of July 2013?
From an from an examination of the retained records on the BBA's files.
Right. So there's something in there that tells you that it was likely published in July 13, yes?
Yes.
Thank you. And in your third witness statement, you tell us that in respect of issue 1 and amended issue 1, the project manager and approvals manager for both were George Lee and Chris Hunt, respectively. Is that correct?
Yes.
Let's go to issue 1 then, dated the 27th of October 2008, at BBA 6038. We can see from the top that it's for the Cool Firm K15 rain screen insulation board. And we can see there's a box underneath that, a pale blue box, product scope and summary of certificate. And then in the left-hand corner, towards the bottom of the page, we can see the date, the 27th of October 2008, and that's been signed by Chris Hunt, Head of Approvals, and Greg Cooper, the Chief Executive at the time, yes?
Yes.
And on page 1, we've got it there on the page, under the key factors assessed heading, we see behaviour in relation to fire is the third bold heading, and it tells us the boards will not contribute to the development stages of a fire or present a smoke or toxic hazard, see section 7. Now, I want to ask you about this particular wording just briefly to see whether you might be able to assist us where Mr. Hunt could not. Can you help us? What does that phrase mean? The boards will not contribute to the development stages of a fire.
I don't know.
So you can't help us as to whether that's derived from guidance?
No.
Or from somewhere else within the building regulations or approved document B?
No. Do you want me to speculate?
Not at this stage. I mean, I'm going to ask you a number of questions about this. I'd rather you didn't speculate. Well, what could the scientific or evidential basis for such an assertion be? Let's put it like that.
I don't know.
Do you understand, and did you understand when you came to be dealing with the K15 product, that it was a combustible phenolic insulation material?
Yes.
As such, can you explain how it could have been accurate to state that the boards will not contribute to the development stages of a fire?
I don't know the basis for that statement.
Because I think we can agree it's not qualified, is it? It's a definitive statement, is it not?
Yes.
Does this assertion concern you at all, looking at it now?
Yes, it does. I would point out that it does refer the reader to the main fire section of the certificate and reiterate that any certificate should be read in full and no decision should be based on the basis of a single sentence. But yes, it does concern me.
Yes, because actually that sentence doesn't in fact appear in section 7, does it?
No.
Can you remember when you first became aware of that sentence?
No, I believe it was removed as part of the replacement of the certificate in 2014, maybe 2015, the 2014 certificate that was issued in 2015.
Do you remember reading it and being concerned about it?
I remember removing it in 2015, yes.
And were you concerned at the time that you removed it?
I didn't feel it was an appropriate clause to insert in the certificate, so yes, I was concerned.
Well, you say I didn't feel it was an appropriate clause. Can we agree that it was inaccurate? An inaccurate statement of how this combustible phenolic insulation would behave in fire?
As I've said, I do not know any scientific basis for making that statement.
Yes. Mr. Hunt told us in his evidence that he couldn't remember reading that wording at the time and asking himself what it meant. And he also said that reading it now, I think it confuses more than it helps. Can I take it from your answers that you agree with that?
Yes.
And just for the transcript, that was Mr. Hunt, day 108, page 173, lines 1 to 6, and page 175, line 2. Do you accept that the most natural reading of that phrase, will not contribute to the development stages of the fire, is that it is a description of something which is non-combustible?
I am not sure whether it would be equally true of something of limited combustibility. That's beyond my experience, I'm afraid.
Either way, do you accept that the wording is misleading, given that K15 is neither non-combustible nor a material of limited combustibility?
If taken in isolation, yes. But again, you must read the full certificate.
Well, you keep adding that caveat, if taken in isolation, you must read the full certificate. But nowhere is that phrase explained, is it, in section 7? It's just a bold statement that appears on the front of the certificate.
Yes, but the true performance of the product, if you wish to describe it in that way, would be given in section 7 of the certificate.
So are you saying that a reader of this certificate should just what, simply ignore that sentence on the first page?
No, they should read the certificate in full and take the performance characteristics given in the certificate against the criteria given in the approved documents.
Right, but what weight should the reader of this certificate give to this statement? The boards will not contribute to the development stages of a fire.
That's an opinion. The factual performance characteristics are given in section 7 of the certificate.
Well,
and if you take the information given in section 7 and apply the criteria given in the approved documents, you can form an accurate picture of where the product can be used.
I see. You say it's an opinion. It's a wholly inaccurate and misleading opinion, isn't it?
I agree. We cannot substantiate it, yes.
Yes. Can you help us? Did the BBA ever receive any queries, concerns, or complaints in relation to this phrase, so far as you are aware?
We did receive some queries about the file wording as a whole. I don't know if they related specifically to that clause.
And who were those queries from?
We had a conversation with NHBC at one point and an inquiry from MHCLG.
Yes, I'm going to come on to the inquiry from MHCLG because I think we have some emails about that. You mentioned a conversation with NHBC. Can you tell us when did that conversation take place?
It was when the certificate was being, it was either reissued or the 2015 replacement, specifically to the wording.
And who was it at the NHBC who you had this conversation with about the wording?
Graham Perrior and Dave Alexander White.
Right. And were they concerned about the scientific and evidential basis for that statement?
As I recall, it was more about the classifications given in the certificate rather than that front page statement.
I see. Why, when you first saw this, did you not investigate how it had come to be included in the certificate in the first place?
It wasn't a process I would normally follow. If I thought a wording in the certificate was inappropriate, clearly I would seek to correct that. If the staff involved were still working in the operational certification side of the business, I would have a conversation with them to establish where it had come from. In this case, both staff members involved had moved on within the business, were no longer working in this area.
Can you help us? Why wasn't that a process that you would usually follow? Even if the relevant staff have moved on, wouldn't you want to understand whether the training was adequate for staff at the time, whether the processes that were being applied for fire performance assessments were robust? Why wouldn't you want to understand any of those things?
Well, the training had greatly increased since the time that certificate was written. We had different project managers, we had different managerial staff in post, and ultimately I was signing off the certificates rather than a colleague. So there was almost no overlap between the processes in place in 2008 and those in place when I came to head the department.
I see. So you decided, did you, that there wouldn't be anything to be learned from investigating how this error had come to occur on the certificate?
I was confident that error would not be repeated, and that the processes we had in place at that point were far more robust than they were at the time that certificate was drafted. I
see. But we know that, for example, Chris Hunt did carry on working in the BBA, albeit in a different department. Why wasn't it important to ascertain how Mr. Hunt could have signed off on this certificate when there was no evidential basis for that statement?
Because he had moved to a non-technical role within the organisation. He was heading up product development activities and no longer in a position to make technical judgments over insulation products.
Did you ever speak to Mr. Hunt about this, about how this came to occur?
Not that I recall, no.
Can we look now at page 5 of this same certificate, BBA 6038, page 5, and section 7 on page 5. We can see at the bottom the heading behaviour in relation to fire. And at section 7.1, we can see details are given of a BS 8414 part 1 test, which is a large-scale fire test, yes?
Yes.
And then also some details are given below that of a BS EN 13641 fire resistance test for non-load bearing elements, yes?
Yes.
And you tell us in your witness statement, we don't need to turn it up, it's paragraph 86 of your third witness statement on page 24, that the BBA was provided with a full copy of the 8414 test report prior to the issue of the first certificate. Now, the description of the 8414 part 1 test includes 6mm cement particle boards. That's in the second line of that bullet point. And this is the same test to 8414 part 1, which is referred to in all issues of the certificate for K15. Do you agree?
Yes.
And we can see at the end of the third line down, so in that first bullet point, at the end of the third line, it begins the cement particle boards. It says this: the cement particle boards provided the overcladding for the rain screen system. Now, did you consider at any stage, or are you aware of any other BBA employee considering that cement particle boards might not be able to be used as the outer layer in a rain screen cladding system on a high-rise building?
I wasn't involved in the drafting of this certificate, but I think that would be an unusual scenario to have an unfinished cement particle board as a cladding.
Yes, and did that occur to you when you came to be involved in these certificates after 2008? That was an unusual scenario to have an unfinished cement particle board as a cladding?
I was aware of it, yes.
Yes. And were you aware that that build-up described was not one that could be replicated on an actual high-rise building?
In what way could it not be replicated, sorry?
Well, for the same reason, because it's a cement particle board, which you wouldn't expect to be used as the outer cladding for a high-rise building.
Yes.
Now, my next question relates to a matter which we may need to deal with at a later stage in this inquiry, but for now, I want to ask you this. Do you recall being involved in early 2014 in any discussions or meetings with the BRE on the subject of any BBA certificate for K15?
Sorry, what was the date again?
Early 2014. Do you remember being involved in any discussions or meetings with the BRE on the subject of any BBA certificate for K15?
I don't recall one, no.
We believe that those discussions may have involved Stephen Howard and Sarah Colwell. Does that help?
I have met both of those individuals. I'm sorry, I really don't recall a meeting about K15. It's not to say there wasn't one.
Right. So you can't remember a meeting with the BRE at which you came to discuss the certificate for K15 and its wording?
Do you know the specifics of what was discussed that might help jog?
No, we're just going on what other BRE witnesses have told us. So that's why we're asking you. We're not aware there's any notes of that meeting.
It is possible, but I don't recall it.
Did anyone at the BRE ever express to you at any stage a view that the 8414 Part 1 test build-up on which Kingspan were relying was a non-standard or non-typical system? Did the BRE ever say that to you?
They didn't, but I was aware of that. I didn't think that was the purpose of the test. It's not a role that I fulfil, but as I understand it, it's very unlikely that a actual site installation will exactly reproduce the construction in the test. I was of the understanding that they would be used as the basis of desktop assessments by suitably qualified individuals to extrapolate those results to particular real-world constructions.
Right, so just so as I'm clear on your evidence, are you saying that the purpose of referring to this test in the BBA certificates was because the BBA understood that that would be used for the basis of desktop assessments in the future?
I understood that I believed that they could be used for that purpose, yes.
I see, but that's not the premise on which they're included in the certificate, is it?
Well, they're included as representative test data for that particular construction. It is for the specifier and the reader to decide whether or not it's appropriate for a particular installation.
Well, we'll come and look at that wording again in a moment, but nowhere in the certificate does it say we've included these details of the 8414 test build-up so that desktop assessments can be done on the basis of it. It doesn't say that, does it?
No, it doesn't. We provide the test data to be used by others on the basis of the requirements of a given installation and the requirements of the approved documents. That certificate does not say it is suitable for use on any particular installation. That is a judgment to be made by others.
Right. Did you understand that that 8414 test data applied only to the exact materials tested in the exact same configuration? Did you understand that?
Yes.
If we go back to page 1 of the certificate, to the product scope section, you can see that at the top, we've got the main Cooltherm K15 rain screen heading, then the lighter box, product scope and summary of certificate. We can see that it says there, this certificate relates to Cooltherm K15 rain screen insulation board, a rigid phenolic board with foil composite facings for use as external thermal insulation on new and existing steel frame or masonry walls. Do you see that?
Yes.
Now that reference to the use of K15 on steel frame walls was not correct in 2008 in relation to buildings with a story over 18 meters, was it?
I'm hesitating. I don't understand what you're asking me.
Let me ask it a different way. Given that the BBA only had evidence of one test to BS 8414 part 1 with a masonry substrate and had no evidence of any testing to BS 8414 part 2 for steel frame structures, it was not correct that K15 could be used on existing steel frame walls in buildings over 18 meters, was it?
Well, with respect, it doesn't say that. It doesn't say that you can use it above 18 meters on a steel frame construction. You could use it below 18 meters on a steel frame construction.
But where does it draw that distinction that you're drawing now? Where does it clearly state that you can only use it on a steel frame construction if it's below 18 meters?
That restriction isn't given in the BBA certificate, it's given in the approved document. And as I've said, it's for the reader to take the data within the certificate and apply that to the criteria given in the approved document.
Why is that not made clear in this certificate? Why is it not made clear that you can only use it on a steel frame building if it's under 18 meters?
It's a fundamental principle of certification. We don't say what it's not suitable for in that way. It may well be that post-publication of this document, a representative BS 8414 part 2 test had been carried out, in which case it would be suitable for that construction to be used above 18 meters.
Yes, but with respect, Mr. Albon, you're not dealing with when you issue this certificate, you're not concerned with what might happen post-publication. Surely the BBA is concerned with what information it has at the time it issues the certificate, yes?
Yes.
And it only had an 8414 Part 1 test, yes?
Yes.
So shouldn't it have made clear that for steel frame walls, it could only be used if under 18 metres? Wasn't that an important qualification to include as part of this product's fitness for purpose? No,
not at all. It's for the specifier for an individual building to read the information in this certificate. As you say, there is no BS 8414 Part 2 test. In its absence, its use, as covered by this certificate, would be below 18 metres. But it's the approved documents that make that distinction, not the BBA certificate.
Mr. Albon, in your first witness statement, you have told us, this is for the reference BBA 50158, page 16, paragraph 64, that the intention is that the certificate is a standalone document that gives the reader all of the information required without recourse to other documents. If it's a standalone document that gives the reader all of the information required, why isn't it clear from the very first page of this certificate that K15 can only be used in one specific construction over 18 metres?
When I wrote of no other documents being required, clearly I was not referring to the statutory instrument or the approved documents that support it. They are the governing documents that decide whether or not a product can be used in a particular situation. The certificate gives the specifier the information they need on which to make an informed judgment. If there is no data within the certificate that allows the use above 18 metres, then clearly it is restricted by the approved documents to below 18 metres.
I see. So far on this page, have I got this right? That the reader is to ignore the sentence under behaviour in relation to fire and understand that the statement about use in steel frame buildings is qualified to only buildings below 18 metres. Is that right?
I wouldn't expect any informed specifier to make a judgment on the basis of the first page of the certificate. I would expect them to read the whole document. If they do that, all of the necessary information on restrictions in relation to location based on fire is given in section 7 of the certificate.
Ms. Grange, can I just suggest this, regardless of what may come later in the certificate, the opening paragraph is simply a description of the product, isn't it, which is designed for use as thermal insulation in different types of construction. Doesn't say any more than that, does it?
Sorry, Mr. Chairman, are you asking me or are you asking the witness?
Well, I'm putting it to you that it's simply a generic statement which doesn't seek to address problems of over or under 18 metres and maybe shouldn't be regarded as defective because it doesn't do so.
Yes, I think what I'm seeking to explore is why we don't see from the very first page of this certificate that K15 can only be used in one specific construction over 18 metres. And that
I'm suggesting an explanation, at least in relation to the first paragraph, namely that the first paragraph is simply generic in its intent and tells you that the product is intended for use in masonry and steel framed walls. It's not addressing questions of height or limitations.
Yes, I understand. I'm really seeking to get to the bottom of why a qualification to that effect only appears in the next issue of this certificate.
Well, you can ask the witness that, of course.
Yes, we'll come to that. Were you aware, Mr. Albon, in 2008 that K15 was being regularly specified for use in the over 18 metre market?
I would have no way of knowing that.
Did you ever become aware of that K15 was being regularly specified for use in the over 18 metre market?
Not pre the Grenfell Tower fire, no.
Let's look at what it says in this certificate about the classification to BR135 of the 8414 test data. If we can go back to section 7.1 on page 5. And we see at the bottom of that page, that same bullet point. And you can see, if we look 3 lines up from the bottom of that paragraph, it says this, it says, within the stated test time, the temperature at the level 2 thermocouples did not exceed 600 degrees C, therefore displaying limited fire spread away from the fire source, and that the product meets the criteria stated within BRE 135. Now, you were asked about that particular wording by the inquiry. If we can look at your third witness statement, page 25, BBA 30100751. And if we look at inquiry question 27I, which is the second question down there, and you're asked the question, on what basis did the BBA deem it acceptable and or accurate to conclude and to state, in the absence of any classification report to BR 135, that the criteria therein had been met? And you, in your answer, you give a detailed explanation of the different aspects of a BR 135 assessment. And then if we can look at what you say at paragraph 94 at the bottom of page 26 of your statement. You say this, you say the BBA considers itself competent to make a judgment as to the results of a BS 8414 test based on the above BR 135 based criteria, when provided with a full report on a performed test. There is clearly some subjectivity to the judgment of the mechanical performance, and this is one of the reasons that it is now standard practice to give report reference details in certificates to enable a specifier to make their own assessment of the results, should they choose to do so. Now, just picking up on the end of that paragraph, was there not also some subjectivity in the judgment of mechanical performance back in October 2008?
Yes.
If that's right, why weren't the report reference details not always given in the certificate? Can you help us?
I don't know. It obviously would have been better had they done so.
Can you help us? When was this practice of giving report reference details introduced by the BBA?
I don't recall the exact date, possibly around 2014, 2015. I'm guessing, to be honest, around that time.
Okay, thank you. So just to be clear, in the absence of a BR 135 classification report, is this right that the BBA carried out its own assessment of the test data in the report against the criteria in BR 135?
Yes, the approved documents do not require a classification report. It requires the system to meet the criteria of BR 135.
And can you help us? Who are you talking about when you say that the BBA considers itself competent to make a judgment about the results of an 8414 test? Are you talking about all project managers? Or who is it within the BBA that would have been competent to carry out those assessments?
Technical experts within the area of insulation.
I see. And what about in December 2013 for issue 2 of the certificate, which you were involved with? Did you carry out that exercise at that time?
I would have reviewed the conclusions of the project manager who would have made the initial assessment. I would have reviewed that conclusion.
I see. So you would have reviewed the conclusion about the R135 criteria, would you?
Yes.
Was the assessment of 8414 test data against the criterion BR135 a normal or regular occurrence for the BBA in October 2008?
I wasn't involved in that time. I believe this was the first certificate of its type, so it would not have been normal at that time.
Right. And who would they be? You say that there were technical experts in the area of insulation who were capable of making these assessments. Who would, can you give us some names? Who would they be?
John Denyer, Gayatri Ramkaran,
right.
Possibly other experienced project managers at the time. Obviously, as with any company, we have some turnover of staff, so putting the relevant staff in the right timescale is quite difficult.
Yes. And what about George Lee, who's the project manager for this certificate?
He was an experienced project manager who had worked in this area for some time, so possibly.
So you would expect him to be making assessments against BR 135 based on 8414 test data, yes?
If it was his first experience of that test, I suggest it would be, then I would expect him to discuss it with management.
And that would have been Mr. Hunt, wouldn't it?
Or a technical expert working in a different department.
Yes. In your third witness statement, I don't think we need to turn it up now. You set out in a table for us all those individuals at the BBA who were involved in drafting the various K15 certificates. And you tell us that Brian Haynes, as the technical manager, you say that for amended issue 1 and issue 1, he provided opinion on the performance in fire of the properties of the product. That's what you tell us there. Can you help us on what specifically did Mr. Brian Haynes provide an opinion about the fire properties of the product?
From memory, I'm sorry, I can't tell you specifically.
So where you tell us in your statement that Mr. Haynes provided opinion on the performance in fire properties of the product, where did you get that from?
There would have been documentary evidence on the file in forms of notes or emails. That's the only way I could have inferred that. I wasn't involved at the time.
And would any such opinion or advice be recorded in writing?
It should be, yes.
If we go to the witness statement of Mr. Denyer, John Denyer, at BBA 30107880, page 24, and I want to look at paragraph 99. The BBA 30107880, page 24. Mr. Denyer says in that top paragraph, in addition, I do have an email on my email archive dated the 9th of June 2008 from the then project manager, George Lee, to our then technical manager, Brian Haynes, requesting an opinion on the BS 8414 test, but I have no record of a reply to this request. And if we could go to that email, we think this is BBA 50255. We can see that there is an email there at the top of the page from George Lee to Brian Haynes, CCing Chris Hunt, saying, hi, Brian, please find attached product description. And we think that's supposed to read 8414, fire report, for which I require a fire opinion. And you can see this relates in the subject to call firm K15. Now, Mr. Albon, we cannot find a response to that email. Do you know whether a fire opinion was in fact provided?
I have found no documentary evidence of such an opinion. It may be that Brian Haynes discussed with George Lee, but I don't know.
According to the BBA's policies and procedures, should there have been a written response to that, providing a fire opinion, if one was provided?
There should be a documentation of any technical judgments made on a project, yes.
Yes. And you can't help us as to why we don't find that in this case. We don't find any fire opinion helping us as to how someone looked at the 8414 test data and concluded that the BR 135 criteria were satisfied.
I haven't found any documented evidence of that decision being made.
No. Just looking back at issue 1 of the certificate and the phrase we were looking at, this is at page 5, BBA 6038, page 5, and looking at paragraph 7.1. So it's summarising the BS 8414 report, and at the very last line it's saying, and that the product meets the criteria stated within BRE 135. And you see there it says the product meets the criteria stated. Do you see that?
Yes.
Now, going back to your third witness statement, BBA 301071, page 27, We can see that you've been asked about this particular sentence at inquiry question 27K. And you're asked the question, on what basis did the BBA deem it acceptable and or accurate to conclude and to state that the product had met the criteria within BR 135? And your response is below. You say, as explained above, the test relates to the specific construction tested, and it would have been preferable not to refer to the product in this section. This was corrected in the second issue of the certificate issued on the 17th of December 2013. Now, I'm not sure that's an answer to the question you were asked, and so I'm going to ask it again. Now, take it in stages. Why do you say it would have been preferable not to refer to the product in this section?
Because as stated, the test relates to a specific construction, and so it is a system test and not a product test.
Yes. So does it follow, do you consider the assertion that K15 as a product had met the criteria in BR 135, do you consider that to have been an accurate assertion?
No, it is a system test, not a product test.
And do you agree that a reader would inevitably conclude that K15 as a product had met the criteria in BR 135?
I would hope that anybody making a judgment on the basis of a complex test such as BS 8414 would understand that that is a system test. If not, that is potentially misleading, yes.
Yes, can we agree that that section of the certificate is wholly inaccurate and misleading?
I think the use of the word product is inaccurate and misleading. I wouldn't say the whole sentence is inaccurate and misleading.
Well, that's the bit I'm asking you to focus on, the statement that the product had met the criteria within BR 135. Can we agree that that is wholly inaccurate and misleading?
Yes, you cannot extrapolate that result to other constructions, including that product.
Quite. Can you explain why was that not corrected until 2013?
I think it's an unfortunate human error that was overlooked during the certificate checking process. So I can't explain it.
Did you ever speak to Mr. Hunt about this inaccurate statement on page 5 of the certificate? I've asked you about whether you spoke to him about the statement on page 1 about whether about the product not contributing to the development stages of a fire. But did you ever speak to him about this inaccurate statement that the product met BR 135?
No, for the same reasons I explained earlier. I don't think it would have added any value.
Mr. Hunt could not account for this kind of error making its way into the final version of issue 1 and also amended issue 1 of the certificate. Can you help as to how that error has found its way into that certificate?
No.
Can we look at the witness statement of George Lee at this point, who you tell us undertook the drafting of the certificate? If we can go to BBA 10794 at page 4. And I want to look at what he says at paragraph 23. Now, the questions the inquiry asked are not included in this statement, just the answers. He is asked by the inquiry what his understanding was of the classification national class naught. And at 23, his response was this: a class naught rating indicates limited combustibility. Do you see that?
Yes.
Now, is that your understanding too, that a class naught rating indicates limited combustibility?
No, that's incorrect.
Back in 2008, was that your understanding, that a class naught rating indicates limited combustibility?
No.
Can we agree that Mr. Lee does not appear from that answer to have a clear or accurate understanding of the meaning of limited combustibility and its relationship to a classification of national class naught?
I would agree that at the time he was writing this statement, he clearly did not have an understanding. He left the BBA, I don't know, 10 years ago. I don't believe he has worked in this area since he left. It may be his memory is inaccurate and that he did understand the difference at the time.
I see. Well, given that he said this in 2019 to us, do you have any reason to think that he would have thought something different back in 2008 when this certificate was being put together?
I think it's inevitable he would have had a better understanding at the time he was working with these products than he would have relying on memory 10 years later. I can't tell you that he did understand the difference at the time. I would hope that he did.
Right. Well, can you explain to us how it could be that a BBA project manager drafting certificates for thermal insulation materials, including Kingspan's products, does not appear in his statement to this inquiry to have a clear understanding of fire classifications?
As I've tried to explain, I think his understanding at the time he was working with these products would have been better than it is 10 years later when he's been working in different product areas.
How can you deduce that, given that on the front page of this certificate, it says this product will not contribute to the development stages of a fire? How can you conclude that he would have had a better understanding at the time he wrote that, a statement which you've admitted was inaccurate and not supported by any evidence?
Well, I think the two things are different. I'm not deducing anything. I'm merely suggesting that if he is relying on his memory from 10 years ago, he may not have the understanding now that he had at the time he was writing certificates. I really don't know.
If we look at paragraph 25 of your third witness statement, that's at page 7. You tell us something about the systems that are meant to be followed. You say the individual level of knowledge possessed by each member of staff is closely monitored by line management, both informally via daily interaction and more formally via annual appraisals against set objectives. As part of this process, needs for further training are discussed and documented for achievement over the year to follow. And then you go on at 26, further project managers and their management are assigned particular product areas in which to specialize as they build their experience. For example, there's a team that works only in the field of thermal insulation. In this way, knowledge can be built on more quickly, liaising with more experienced colleagues working in the same team, as opposed to working across the full range of product covered by the BBA. Now, can you help us? Was George Lee a specialist in thermal insulation?
He worked largely in the field of thermal insulation. He was not an expert in thermal insulation in the way that some of his colleagues would have been.
I see. What about Mr. Hunt? Was he an expert in the field of thermal insulation?
No.
Do you consider that it's possible that Mr. Lee may have included the phrase will not contribute to the development stages of a fire on page 1 of the certificate, which we've looked at, on the basis that he believed K15 to be a material of limited combustibility?
If he believed that the material was of limited combustibility, I believe he would have included a statement to that effect in section 7 of the certificate. So I think it's unlikely it was on that basis.
I see. Have you at any stage been aware of confusion in the wider industry about the meanings of class 0 and limited combustibility?
I'm not aware of any confusion between those two terms. They're both clearly defined within the approved documents.
Can we just look briefly back at another passage in Mr. Lee's witness statement? So BBA 30010794 on page 6. we go to paragraph 44A, this is about whether or not the BBA was accredited by UCAS to interpret fire test data. And Mr. Lee has answered, not to my knowledge. At the time of my employment, this would be the reason to obtain a fire opinion, as the BBA were not accredited to interpret fire test data. Now, is he right about that?
No, I think he has a limited understanding of the accreditation process.
Yes, so in fact, the BBA was accredited to interpret fire test data, yes?
It's not really the way accreditation works. We are accredited to assess and certify products. The scope of that accreditation is limited by UCAS to certain product areas. Within those product areas, there are a wide variety of product parameters we are required to assess and understand. Fire is one of those, and so it is included under the accreditation, but it is not a direct part of the accreditation.
Can you explain why Mr. Lee thought that the BBA were not accredited to interpret fire data?
I think from what I've seen of his statement, he is consistently relying on memory and not giving answers that are credible.
I see. Let's move on now to section 7.2 of this issue 1 of the certificate on page 5. If we can go back to that, BBA 6038, page 5. Right at the bottom, we can see section 7.2. It tells us there the product is classified as class 0 or low risk, as defined in the document supporting the National Building Regulations. The product therefore may be used in accordance with the provisions of, and then over the page, it tells us England and Wales, approved document B, paragraph 8.4, volume 1, and paragraphs 12.5 and 12.6, volume 2. See also diagram 40. So that's what we see about class 0 in this first issue of the K15 certificate. And I want to ask you about what fire test data was provided by Kingspan at any stage to evidence the assertion that K15 had achieved class 0. If we can go first to one of the witness statements provided by Mr. Brian Moore to the inquiry at BBA 11097. This witness statement is dated the 18th of November 2020. And if we go to page 4 and look at paragraph 3M, we can see that Mr. Moore has been asked about the technical assessment by the BBA of K15, and in particular, the assertion that K15 had achieved a classification of class 0. And he states there, if we look at 15 and then 16, he says, Certificate 084582 and the first issue of Certificate 145134 stated that the product was a class 0 low risk material. In order to demonstrate this, test reports are required to BS 476 Part 6 and BS 476 Part 7, and no such reports are contained on any of the K15 file folders. And then he goes on in 16, he says this, instead, the classification for K15 was extrapolated from a series of fire reports on similar Kingspan phenolic products, including those of a similar density and facing type. And then he says that copies of the reports are exhibited to his statement. And Mr. Moore was asked about this during his oral evidence, and I want to take you to what he said then. If we can go to the transcript at day 107, page 167, line 7. He's being asked about this exercise of extrapolation, and this is the answer he gives, picking it up in line 7. He says, well, if there are no Kingspan, if there are no fire reports to justify the class 0 statement, on what basis was the BBA including this in a certificate, was the question that I asked. and Mr. Albon's view, a very experienced and senior person at the BBA, his view was that it was more likely than not that it was extrapolated from a series of fire reports on similar Kingspan phenolic products, including those of similar density, i.e. the material referenced at Exhibit BM4. You'll recall that at the start of my statement, I did clarify that wording as deduction, belief, rather than an absolute. There is a formula here that someone has extrapolated from a series of fire test reports. Now, can you help us? When did you first conclude that an extrapolation was likely to have taken place?
When I was asked as part of the inquiry's questions.
And so was it the case that you looked back at the K15 files, found no evidence of BS 476 Part 6 and Part 7 testing, and therefore concluded that there must have been some form of extrapolation? Is that right?
It's a little more than that. There is no evidence of the necessary BS 476 test reports, but the project manager had placed within that specific technical folder a number of associated Kingspan fire test reports to those standards. They would only be on that folder if they had formed some part of the assessment of K15. There is nothing directly linking them to the conclusions drawn, but I inferred from the fact that they were placed on the file that an extrapolation had been made on the basis of those reports. But is an inference, I can't confirm that.
I see. Did you ever consider as an alternative possibility that those responsible for drafting the certificate simply accepted Kingspan's claim in their own marketing literature that K15 was class 0 and included that claim in the BBA certificate without carrying out any extrapolation exercise?
If that were the case, I don't know why the project manager would have placed these reports, which were collated from other assessments we had carried out, on this specific assessment folder.
Would it have been in accordance with the BBA's procedures at the time to have taken Kingspan's marketing literature and to replicate what was in that, because that said class 0?
Absolutely not. There should be a defined and documented technical assessment to back up any statements made in the certificate.
Did you actually check with either Mr. Lee or Mr. Hunt what had led to the inclusion of the class 0 statement in the certificate?
No.
And just to be clear, you're not suggesting that you yourself ever carried out any such extrapolation in relation to K15 and class 0, are you?
No, I'm not.
Now, going back again to your third witness statement, BBA 30100751, page 21, and looking at the top of page 21 and inquiry question 23D, you were asked the following: on what basis did you or any other employee or agent of the BBA consider it appropriate for the BBA to extrapolate in the manner described instead of requiring the relevant test reports? And your answer at 70 was, I was not involved in this process and so I'm unable to comment on the details of the technical assessment made. Now, I'm not sure that was actually an answer to the question. Is this right, that you do not know for a fact that such technical assessment was actually made?
There is no documentation on file to confirm that, so I can't be sure, no.
Can I ask you this, whether or not an extrapolation was actually carried out on this occasion, on what basis do you consider that it would ever be appropriate to extrapolate from test reports for various products to pronounce a classification to national class 0 for a different product?
That would depend on the circumstances and the individual carrying out the assessment. It's not unknown for an insulation manufacturer to produce identical products for exactly the same, for different purposes. So it may be there is an absolutely identical product used for roofing and for cladding. Now, if we had a fire test report on that product and we knew for certainty that it was to an identical formulation and specification, it might be appropriate to transfer that classification across. Equally, if we had a letter of opinion from a suitably qualified individual at a UCAS accredited fire laboratory that they had carried out an extrapolation, we might be prepared to accept that, but we would not carry out that type of technical judgment within the BBA.
Right, so taking this in stages, can we agree that there wasn't an absolutely identical product to K15 that you could simply take information for in this instance?
I don't know.
When you say you don't know, did you check the products? I'll come to it in a moment. The products that you say were referred to on the file, and check whether they were an absolutely identical product to K15.
Well, I wasn't involved in the assessment process at the time, so no, I wouldn't have done that.
No, and the file doesn't reveal any opinion being provided by a UCAS accredited fire laboratory, does it?
No.
Suggesting an extrapolation.
No.
If we look again at the evidence of Mr. Moore, if we can go to the transcript of day 107, page 170, line 17. Day 107, page 170, line 17. He says this, he says, I understood that it wasn't common, but it was not unusual if there were products of a very similar kind to each other. And if the performance was adjudged to be so similar to one that we'd already assessed, it was not unusual for the BBA to extrapolate its opinion from one product to a similar one. That was the core of the conversation. And then he's asked, is what you've just told us something that John Albon told you, or is it something you're telling us from your own knowledge and experience? So if we go over the page to the top of the next page. Yes, from your own knowledge of experience. And he says, it's something that I'm saying arose in my conversation with Mr. Albon based on his knowledge and experience across many, many years, more than me at the BBA. To me, that sounded, and I think this material was actually in the place where the fire test reports would be in the particular folder. So it was far from, it wasn't a leap of faith, it was a reasonable deduction to be drawn, and that was the basis for the belief. Now, is Mr. Moore correct that he's saying that it wasn't unusual if there were products of a very similar kind to one another, and if the performance was adjudged to be so similar to one already assessed, it was not unusual for the BBA to extrapolate opinion from one product to a similar one? Do you agree with that?
I don't think that's inconsistent with the explanation I just gave. It would depend on the circumstances individual to the case.
Mr. Albon, I think it is inconsistent because you said that if there was an identical product, you would extrapolate. And Mr. Moore here is referring to products of a similar or of a very similar kind. So which is it? Is it only where there is an identical product that you extrapolate? Or is it where there is a similar or very similar product that you would extrapolate test data of this nature?
If it was identical, the BBA could make that judgment. If it was not identical and it was the similar scenario, I would expect us to obtain an expert opinion from outside of the BBA.
Okay, so it sounds from what you're saying like Mr. Moore was wrong, that it was not unusual for the BBA to extrapolate from one product to a similar one. He's wrong about that, yes?
I think it depends what you mean by, or what he means by the BBA would extrapolate. We would potentially take a classification and use it, but it may be based on a judgment made by somebody from outside of the BBA.
I see. Can you help us, in what other circumstances and for what other products or manufacturers have such extrapolations ever been carried out? Can you give us some context to this?
It's not uncommon that we have a fire test report that has a limited scope of applicability, for example. We might then ask our certificate holder to seek a letter of opinion from the organisation that carried out the fire test to expand that scope of applicability, for example, for thickness of insulation. It may have a limited thickness within the scope of the fire test report, but the fire laboratory might be prepared to expand that thickness to match that which the certificate holder wants covered in the certificate.
Yes, now that scenario is not quite the same as what I'm trying to get at. I understand that if you've actually got an extrapolation carried out by a third-party assessor, that's a different thing. But going back to what the BBA itself does, can you help us? Have the BBA ever carried out other extrapolations for other products or manufacturers, like the one that we see referred to for K15 and Class 0?
I'm not aware of our having done what you're suggesting, unless it was the scenario I explained previously where it was the same product being used for two different applications.
So are you saying this is the only time you've ever come across this, the K15 situation in Class 0, the only time you've come across an extrapolation from similar products?
Well, I don't know what the extrapolation was. That's the problem that I have. I don't know what work was done because it's not documented on the file. So I find that difficult to answer.
Do you consider that extrapolation is a process permitted by the BS 476 Part 6 and Part 7 test standards? Mr. Moore was not able to help us on that question and said he didn't know the answer. Can you help us?
It would certainly be beyond the competence of the BBA to carry out that. We would expect an expert fire opinion if we were to do something outside of what was defined within the fire test standards.
I see. Do you know, did the BBA follow any particular guidance when carrying out these extrapolations?
Again, unless I know what extrapolation was carried out, no, we did not have a procedure for extrapolating fire test reports because I would not expect us to be doing that.
Are you aware as to whether the BBA has ever had a discussion with a fire engineer external to the BBA about the concept of extrapolating test data from different products?
Not that I can recall.
If we go back to your third witness statement at page 21, in the middle of page 21, you were asked at E, on what basis did you consider that the BBA was entitled to describe a Class 0 product which had not, to the BBA's knowledge, achieved that classification? And you tell us at 71, a technical assessment would have been made. There are reports on file relating to the insulation foam component used and various faces, and I assume that these were used to make a fire engineering assessment of the likely performance of the K15 product. Now, you can take it from me that the reports to 476 Part 6 and Part 7, which Mr. Moore told us that he found in the test data area of the K15 file and are exhibited to his second witness statement, what I'm going to do is just summarize those for you. What we see is an unfaced CFC-free phenolic foam laminate test to BS 476 Part 7 from August 1991, a K7 sarking board test to BS 476 Part 7 from February 1993, K9 with a glass tissue, not a foil facer, tested to BS 476 Part 6 from October 1993, K9 with a glass tissue, not foil facer test to BS 476 Part 7 from October 1993, K8 cavity boards with a glass tissue, not foil facer, tested to 476 Part 6 and Part 7 in a letter from July 1994. Cooltherm DL 2000 with one aluminium face and one glass tissue face, tested to BS 476 Part 6 from October 2003. Cooltherm DL 3300 with one aluminium face and one glass tissue face, tested to BS 476 Part 7 from October 2003. And finally, an assessment report to 476 Part 6 and Part 7 on Cooltherm DL 3300 with one aluminium face and one glass tissue face from December 2003. Now, I've summarised those test reports to you. Can you explain and help us, in the light of those, what led you to the assumption that those reports were used to make a fire engineering assessment, as you describe it, of the likely performance of the K15 product?
The only basis on which I formed that impression was the fact that they had been placed on the file for K15. There would be no reason for them to be on the file unless they had been used. I would not be competent to make that technical judgment. I don't know on what basis that judgment was made.
No. Have you actually read those reports for the other Kingspan products yourself?
I may have glanced at them when I put the file together for the inquiry, but no, I didn't study them in detail.
Had some form of extrapolation been conducted, what consideration do you think ought to have been given to the fact that these reports were, some of them, very old? One of them was already 15 years old by 2008. Should that have been a consideration in any such assessment?
The age of report should always be a consideration. It's not to say because it's 15 years old, it can't be used, but you would need a good case in order to be able to use a report that was that old.
And what considerations should have been given to the fact that none of those products appear to have had the same facer arrangement as K15, i.e. foil faces on both sides of the phenolic core? What considerations should have been given to that?
I think that would be for a suitably qualified fire expert to decide. It's outside my competence to judge. It may be that a judgment could be made on the known performance of those faces, but I don't know.
Mr. Albon, you're the BBA's Chief Scientific Officer. If it was outside your competence to judge, wouldn't it have been outside the competence of the project manager and the head of approvals who were considering this certificate at its time?
I don't think they would have been more qualified to make a judgment than myself or other colleagues we have in the business. I don't know who made the decision and on what basis.
Does it follow from your answers that you can't tell us how that extrapolation exercise could have been done, that you can't take us through the steps as to how you would conclude that it can be classified to class 0?
No, I can't.
Did you take steps to find out from Mr. Hunt who was responsible for the technical sign-off of that first K15 certificate and whether your deductions on the matter were correct?
No.
Can we go to BBA 3011093? This is a letter dated the 2nd of December 2004 to Ivor Meredith, and it's signed, we can see at the top of page 2, it's signed by Simon Lloyd of the BBA. And if we go back to the main, yes, thank you. Go back to the main part of the letter, we can see in the opening paragraphs that the letter is chasing a response to an earlier letter from the 7th of September 2004. It says, on consulting our records, we've not received a reply from you to our letter date of that date. And at the second paragraph, he states, we would like to point out that we are unable to proceed with the work until we have received the information requested. And underneath that, Mr. Lloyd has listed out various outstanding pieces of information, including just over halfway down the list, reaction to fired data and surface spread of flame. Do you see that?
Yes.
It is apparent from your witness statement and that of others at the BBA that there was no fire test data to BS 476 Part 6 and Part 7 provided to the BBA on K15 prior to issue 1 of the certificate. Do you agree with that?
Yes.
As far as you were aware, when did the BBA first receive test data showing tests of BS 476 Part 6 and 7 for K15, which would confirm a Class 0 classification?
I don't think we ever did.
No, that seems to be the position, but we just wanted to confirm it with you, that you never actually received test data to those parts of 476 Part 6 and 7.
I think I've seen Euro classification data, but I don't recall seeing a BS 476 set of reports.
Did you ever consider that there might be a reason that that data was not forthcoming from Kingspan when requested?
I was not involved at this stage of the assessment. I think my initial involvement was when we had the C category to the Euro classification system.
Whose responsibility would it have been to ensure that this fire test data had been received for K15 in October 2008 when the certificate was first issued?
Initially, the project manager, and then when the final certificate was reviewed prior to issue by the individual making the certification decision.
Yes, and what about on the 17th of December 2013 for issue 2 of the certificate? That certificate carries your signature as head of approvals, doesn't it?
Yes.
Was it your responsibility or somebody beneath you to ensure that that fire test data had actually been received for K15?
The content of the certificate was entirely my responsibility. However, it's not part of normal BBA procedure to go back and repeat the initial assessment as part of a reissue. During a reissue, we focus on the changes that we are making to the certificate. We don't go back to the original first principles assessment that was carried out for the first issue of that certificate.
I see. So that error was made and it just wasn't picked up in later issues of the certificate. Is that correct?
Yes.
But should it have been? Should someone have checked at the time of issue 2 in December 2013 that there was in fact that test data available?
That would not form part of our normal procedures. We would expect that the statements made on a certificate can be justified.
Can you help us as to why it's not made clear in any of the K15 certificates that that Class 0 classification has been reached by way of an extrapolation from similar products?
I don't believe that would be significant. If the product can achieve a Class O rating, it can achieve a Class O rating. It's a black and white can or cannot. It does appear in this case that we cannot justify the fact we made that statement.
Are you aware now that during the lifetime of this certificate, Kingspan had obtained test results, which in fact showed that K15 was not able to achieve Class 0?
I have seen that reporting as part of this inquiry, yes.
Are you able to accept, as Mr. Hunt did in relation to issue 1 and amended issue 1, that this was a very basic failure of due diligence on the part of the BBA?
Yes.
And you told us that when you signed off on the issue 2 of the certificate, that you'd already become concerned about the assertion on page 1 of the certificate about not contributing to the development stages of the fire. In those circumstances, why did you also not check the other assertions in the certificate before it was reissued?
I think there was a difference between an inappropriate and misleading wording and a statement based on fact, given criteria contained within the approved documents. I had no reason at that point to believe we did not have the necessary supporting information on file.
I see. So you're saying at the time you would draw a distinction between inappropriate and misleading wording as compared with a statement based on fact, yes?
I think the wording is subjective. The statement on Class O was objective, and I had no reason to believe we would not have that data on file.
So it didn't occur to you, once you'd found one major error with the certificate, it didn't occur to you to check that there weren't others?
I would have read, I hope, the rest of the certificate. I regret the fact I did not pick up that misleading wording on the front page.
But what about the Class Naught statement?
As I've said, there was no reason to suppose we wouldn't have had that information on file.
Right. So you don't regret signing off on that?
Yes, I regret not doing it, but I don't think I would have been expected to go back and check it. I think it was a reasonable assumption to make that those reports would be there to enable us to make that statement.
I see. Mr. Chairman, I think that would be a good moment for our afternoon break, if that suits you.
Yes. How are we doing? Question I keep asking you, I know, but still I'll ask it again.
Yeah, we're doing well. If we do go into tomorrow, it won't be by very much, and I'll do my best to see if I can conclude the remaining questions today. But these topics are important. I don't want to feel like I'm rushing them. So
No, well, I'm not seeking to rush you. I'm just inquiring. All right. Thank you very much, Mr. Albon. We'll have a short break at this point. Today we'll be a bit tighter. We'll come back at 3:55 to 4, please. All right, and please don't talk to anyone about your evidence on the break. Okay. Thanks so much. See you later. Welcome back, everyone. We're ready to continue with Mr. Albon's evidence, if he's there. So the first question is, are you there, Mr. Albon? Can you see me and hear me clearly?
Yes, I'm here.
Good. Thank you very much. And you're ready to go on, I hope.
Yes.
Right. Thank you. And Ms. Grange, when you're ready.
Yes, thank you, Mr. Chairman. Yes, Mr. Albon, now thinking back to that first K15 certificate in October 2008, it's right, isn't it, that no initial assessment or audit as to the manufacture of K15 had been carried out prior to that certificate being produced, yes?
Yes.
And if we look at your third witness statement, BBA 30100751, page 22, and I want to look at what you say at paragraph 74. Now, just focusing on the first 4 lines of that paragraph, you say, for an assessment of a new product for a new client, it is normal practice to carry out an initial factory inspection. However, in this case, Kingspan held other certificates for very similar products that were manufactured in an identical way using the same foam insulation and very similar faces. Now, just pausing there, how would anyone at the BBA know that the K15 was manufactured in an identical way to other similar products if there had been no assessment of the manufacturer or production process for K15?
Well, the assessment of production is based on an internal BBA document known as a quality plan. We would have had a quality plan for production at Kingspan's factory, covering all of the then certified products. And as part of the assessment of K15, we would have updated the quality plan to also include the K15 product. From a desktop examination, it would have been clear that the same raw materials, the same manufacturing line, same quality control procedures, the same equipment and the same staff would have been involved in the production of K15 as had previously been certified for these other Kingspan certified materials.
Right. You say from a desktop examination, it would have been clear that the same raw materials, the same manufacturing line, the same quality control procedures, the same equipment and staff would have been involved. How would the BBA know that from a desktop examination if they hadn't actually gone and seen the manufacturing production process themselves?
Well, we would have seen the manufacturing process for these other products because we inspect and audit the factories on a 6-monthly basis. So we would have had a very high level of familiarity with the factory environment. Post-certification, the surveillance would commence for K15 and the assessment process was validated by the fact that when the auditor was in the factory, it was confirmed that the process was as described in the quality plan document.
I see. Are you effectively saying that an assumption would have been made prior to the first issue of this certificate that the manufacturing process was identical for K15 as it was for other Kingspan products? Is that what you're saying?
No, it would have been documented on the basis of information provided by the manufacturer and assessed by the project manager as part of the update of the quality plan document.
So you would take it on trust that what Kingspan was telling you about its manufacturing process was correct, yes?
It would have been informed by existing knowledge and experience of the process, and it would have been validated as part of the normal surveillance process immediately post-certification.
Yes, but that's after the issue of the certificate. I'm focused on what happens before the certificate is actually issued. And what I'm asking is whether you take on trust Kingspan's assertions that the manufacturing process is identical.
There is no physical validation until the first surveillance visit, but there would be a very high degree of confidence based on our previous knowledge of these types of materials.
Yes, I see. Can you help us? In what other circumstances has this occurred? have other manufacturers had such assumptions being made about their products without?
I wouldn't use the term assumption. I think it's a considered technical judgment. But yes, that principle has been applied in other processes.
When you say the principle has been applied in other processes, can you give us some examples of products or manufacturers where similar assumptions have been made about the manufacturing process being similar to other products?
It may be applied in situations where it is a very large scale piece of equipment. It is very difficult to vary the process parameters, such as damp-proof membranes.
I see. Now, in relation to that desktop assessment or desktop exercise, which you say took place on this occasion relating to the BBA quality plan, by whom was that exercise carried out? Who did that desktop assessment?
It would have been initially the project manager. Quality plans are signed by a line manager. The title of those managers has changed over the years, but it would have been assessed and checked by a line manager.
I see. So would it have been carried out by George Lee and then checked by Christopher Hunt?
I would expect so, yes.
And can you help us as to why we don't see any documentation to that effect on the file?
No, I can't.
I want to ask you now about the amendments that were made to issue 1 of the certificate. If we can go to BBA 6037 and we look on page 1. We can see in the bottom left-hand corner of the certificate that it still carries a date of first issue of the 27th of October 2008. But underneath that date, we see in very small print, it says certificate amended on the 6th of April 2010. Do you see that?
Yes.
So just to be clear, this is still the first issue of the certificate, but an amended version of it was produced. Is that correct?
Yes.
And if we go back to your third witness statement, BBA 10751 at page 30, and look at paragraph 111, you tell us, you say, although the date of the amendment is given on the certificate as the 6th of April 2010, in fact, it was not published until the 12th of July 2013 and was superseded by the second issue dated the 17th of December 2013. Now, just to be clear, did you read the amended issue 1 of the certificate before it was published in July 2013?
No, I don't think so.
And I think you've told us that from documents on the file that the best guess that you've got is that amended issue 1 was published on the 12th of July 2013. Is that correct?
If that's the date I gave, yes.
Can you help us? What was the reason for the delay of over 3 years between the amendment date, 6th of April 2010, and the publication date? Can you help us with that?
I'm sorry, I don't know.
Isn't that an extremely long time for the certificate to be awaiting publication?
Yes.
Is this unusual in the experience of the BBA?
Yes, amendments are only intended to allow very minor changes to a certificate. It should be a straightforward process.
Can you help us as to what was happening with the certificate between April 2010 and July 2013, as far as you are aware? Was it simply sitting waiting to be published, or was something else going on?
As far as I can recall, I wasn't involved, so I don't know.
And can you help us as to what it was, what happened in July 2013, which actually resulted in the certificate finally being published?
Again, I'm sorry, I don't know.
I want to go back a little in time and ask you about an exchange with Kingspan that occurred shortly after the publication of the first version of the certificate, issue 1, without amendments. The BBA wrote to Kingspan on the 24th of December 2008, so only 2 months after the certificate was first published, proposing some amendments to the wording. If we can look at some emails on that, if we go to KIN 402093, and I want to look at the email on page 2. There's an email there from George Lee to Gareth Mills on the 24th of December 2008, 9:50, copying in Mr. Hunt about Kingspan Coultham K15 rain screen insulation board. And Mr. Lee begins by saying, "Hi Gareth, we've recently received a number of comments on the K15 certificate in relation to the clarity of wording used as part of this certificate's fire section. In response to this, we have a suggested amendment to the text which we wish to make. This amendment we will make at no cost to yourselves and as an improvement to the certificate, which I hope you will agree will improve how this certificate will read in the future." Now, have you seen that correspondence previously, prior to looking at it for the purposes of the inquiry?
Not that I recall, no.
Can you help us as to what comments had been received by the BBA about the clarity of wording used as part of the fire section?
No.
Have you ever asked anyone else in the BBA about that?
No.
If we look at the third paragraph of this email, where we then have some bullet points, George Lee sets out the changes that he proposes to the certificate. And in the third line down, we can see that in relation to the key factors assessed point, behaviour in relation to fire, he wishes the certificate to be amended to state the boards are classified as class 0. The boards will not contribute to the development stages of a fire. And then this is the new part. The product has been tested to BS 8414 part 1 for a specific construction on masonry walls. So that sentence in the certificate is what's new, that making clear it's been tested to BS 8414 part 1 for a specific construction on masonry walls. Now, can we agree that that amendment to specify that K15 could be used over 18 metres with one specific build-up only on masonry walls was a fundamentally important amendment, wasn't it?
It certainly improves the clarity, yes.
Yes, and to set this out on the front page of the certificate would have made absolutely clear to the reader the limitation on the use of K15 over 18 metres to one specific configuration. Do you agree?
Yes.
And were you aware when you came to be involved in this certificate that the BBA had proposed its amendments to clarify the use of K15 over 18 metres as early as December 2008?
No.
Were you at any stage aware of any role that Kingspan might have played in delay in issuing the amended version of issue 1?
No, when I came to this certificate, it was in the final stages of the second issue. I was not aware of the correspondence prior to that.
Do you agree that Mr. Lee, if he didn't get a speedy response to this email suggesting amendments to improve the clarity of the wording, he ought to have chased this up with Kingspan as a matter of urgency?
I agree this is an improvement, and I agree it should not have been allowed to delay for 3 years without knowing the details. But I have to reiterate that no one should be making a judgment on the fitness purpose of the material on the basis of one statement on the front page.
I see. Let's go to amended issue 1 again. So that's BBA 6037 at page 5. And look down to section 7, behaviour in relation to fire. Now, this section has changed in this amended issue 1. It still states that the product is classified as class 0 or low risk. That's the same in 7.1, as defined in the document supporting the national building regulations. But then this bit has changed. It says the product therefore may be used in accordance with the provisions of. And then for England and Wales, it's got approved document B. And you can see that for volume 2 of approved document B, it now says not only that paragraphs 12.5 and 12.6 are there, but also 12.7. So it's now saying the product therefore may be used in accordance with the provisions of 12.7 of volume 2 of ADB. Now, going back to your third witness statement and page 31 of that, BBA 301071, page 31. Question A, there at the top of the page, there's a short question. Why was reference to paragraph 12.7 added to this section? And you say this at paragraph 113, as above, I was not involved in the preparation of this certificate, but I believe that this reference to 12.7 relates only to the product's use in masonry construction. Section 12.7 states that any insulation product used above 18 meters must be a material of limited combustibility, but also that this restriction does not apply to a masonry cavity wall construction, which complies with diagram 34 in section 9 of the approved documents. Since the certificate covered the use of both masonry cavity wall and rain screen systems, the product could be used in a suitable masonry construction without height restriction, provided the requirements of diagram 34 were met. Now, I'm going to come to ask you about the substance of that answer in a moment, but can I just ask you this? First, when did you come to form the belief that the reference to 12.7 in amended issue 1 related only to the product's use in masonry construction?
When I was asked to prepare this witness statement.
And what led you to form that belief? Where did you get that from?
From my knowledge of the product and the approved documents, I believe my suggestion is the only way in which that statement could be correct.
I see. If we look again, within this third witness statement at page 49, paragraph 191, you make the point very confidently there. If we look at that in the first 5 lines, you say, as described in point 35 above, the statement relating to the use of the product in accordance with the provisions of clause 12.7 of approved document B, volume 2, related exclusively to its use in masonry construction. It did not cover the product's use as part of a rain screen cladding system, for which above 18 meters a material of limited combustibility rating was required by the documents supporting the national building regulations. So just to be clear, this is in fact your view formed at a later stage, is this right, of what the author or person approving amended issue 1 might have intended, yes?
Yes, I was not involved in drafting that statement.
Have you spoken at any stage to either George Lee or Chris Hunt about what their reasoning was at the time for including this reference to 12.7 in amended issue 1?
No, neither individual worked for the BBA, and I was aware that both were being asked to provide their own witness statements, so I did not think that would be appropriate.
George Lee, in his witness statement, did not appear to be able to offer any reason as to why this reference to 12.7 of approved document B was added to amended issue 1. And that would tend to suggest, would it not, that he might not have had in mind the reasoning that you now suggest?
It's difficult for me to know what Mr. Lee had in mind when he drafted that certificate, but I'm not suggesting that was his intention. That's the only way I can see in which that clause would be correct.
Yes. Can we just look at Mr. Hunt's oral evidence on this? If we go to the transcript at day 109, page 56, line 13. So picking it up at line 13, he is asked, what do you mean it may have been related to masonry cavity walls? Can you explain? And he says this, well, having thought about it more recently, again, obviously with the, looking at the certificates and the available files, and I think that that reference was probably related to masonry cavity construction because that reference appears in approved document B. There is that reference to masonry cavity walls and masonry external walls are mentioned in this certificate. And then going on in the next question, yes, that is something that you've considered fairly recently, may have been the reason for the inclusion of that wording, is that right? And then going on to the next page, he says, yes, but it seems to me now that that was also the likely situation at the time. Now, Mr. Hunt does not appear to know for certain what the reason was for including that wording. Can you help us with this? Does the BBA keep records of significant amendments made to certificates and the reasons why such amendments are made?
We do now. In this case, the records are sparse.
Based on BBA procedures at the time, should there have been a record as to why this amendment was being made in amended issue 1?
Yes, this goes beyond what I would normally expect to see carried out under an amendment. I would expect to see more documentary evidence that is in fact on file.
Yes, so just to be clear, you would expect to see some written document setting out the rationale for adding in clause 12.7 of approved document B into this amended issue of the certificate, yes?
No, not at that level of detail. I would expect to see key technical decisions documented. We do not explain the rationale behind every single clause in a certificate.
This was a significant amendment, wasn't it?
I don't think it's particularly significant, is it? It's addition to one clause that's available in the approved document.
Well, let's look at it. Were you aware in April 2010 of the wording of paragraph 12.7 of approved document B?
Yes.
Let's bring that up. This is the 2006 edition at CLG 1607, page 96. There we have clause 12.7 and it's headed insulation materials / products in a building with a story 18 meters or more above ground level. Any insulation product filler material, not including gaskets, sealants and similar, etc., used in the external wall construction should be of limited combustibility. See Appendix A. This restriction does not apply to masonry cavity wall construction, which complies with diagram 34 in section 9. Now, do you agree that other than masonry cavity wall construction, the whole thrust of that paragraph is that all insulation products being used in the external wall construction of buildings with a story over 18 meters should be materials of limited combustibility?
Yes, and this product is not of limited combustibility, and the certificate does not state that it is of limited combustibility.
Well, how then, if it's not a product of limited combustibility, how then could K15 be used in accordance with paragraph 12.7 of approved document B, which is what this certificate said?
I think it's capable of misinterpretation. The only way in which it could satisfy would be for the masonry cavity wall construction. But if this product was of limited combustibility, the BBA certificate would very clearly state that in the fire section. I think it's an enormous leap to go from compliance with 12.7 to inferring that a material is of limited combustibility.
How is that an enormous leap when that is the entire thrust of paragraph 12.7, Mr. Albon?
Well, it's not the entire thrust because it goes on to state this restriction does not apply to masonry. I agree it's potentially misleading, but once again, you have to read the whole certificate. And if you had gone on to read, or the specifier had gone on to read the fire section in its entirety, it does not state this material is of limited combustibility. And if it was, the BBA would explicitly state that it was.
It also doesn't state this material is not of limited combustibility, does it?
Well, it's completely impractical to state every single thing that a product isn't. Our process is to state what a product is, and it's not sensible to infer that it is something that the BBA does not state it is.
Yes, but you're saying that had the certificate been read in its entirety, the reader would have realised that this reference in 12.7 was only to an exception in 12.7, yes?
Yes, I accept if taken in isolation, that clause is potentially misleading, but it should not be taken in isolation.
Yes, but what I'm interested in is what was it elsewhere in the certificate that would have informed the reader that the product was not of limited combustibility when there's no such statement anywhere else in the certificate?
As I've said, I think it is completely impractical to state what a product isn't. We can only state what a product is. It's not non-combustible either, and we don't state that. We do say, without sufficient evidence at the time, that it's class O. We go on in a later edition to say that it's category C. But at no point do we say it's of limited combustibility.
I see. So are you saying that a reader of this certificate would not be led to conclude by reference to that 12.7 reference that this product was of limited combustibility?
I think that clause is potentially confusing, and I would expect a reader then look for further confirmation that it is of limited combustibility. Not finding that, they would conclude that it is not of limited combustibility.
I see. Do you agree that to have added paragraph 12.7 onto that BBA certificate for K15 was misleading and potentially dangerously so, given that K15 was a combustible phenolic foam?
I agree it's misleading. I don't agree it's dangerous because, again, you should read the whole certificate and it does not state that that product is of limited combustibility.
I see. Let's go to your third witness statement at this point, page 33, paragraph 125, BBA 30107551, page 33. Here, you are being asked at 44 why the reference to 12.7 of approved document B was subsequently removed in the next issue of the BBA certificate for K15, dated the 17th of December, i.e. issue 2. And you say this at 125, you say the certificate wording was changed as part of a general BBA policy of not repeating information given within the building regulations within the main text of the document. For this reason, all references to approved documents and mandatory standards were removed from this section as part of the second issue. The revision did not relate to 12.7 alone. And then going on to paragraph 126, you say the opportunity was taken to revise the wording in line with other BBA insulation certificates as the style and format had evolved since the issue of the certificate in 2008. It is BBA policy to maintain consistency of approach for a given product type, and this often means rewording of sections during certificate reviews. In other words, is it right that your evidence is that the removal of the reference to 12.7 of ADB was not specific to that particular section, but simply part of a wider process of stylistic change, which happened to be going on at the time. Is that right?
Yes. At the time, I was not aware of the perceived significance of that reference to 12.7. I did become aware of that at a later point with correspondence with DCLG, but at that point, this certificate had, I believe, already been reissued.
I see. Well, let's look at that exchange of correspondence now between you and Mr. Brian Martin from the DCLG in respect of amended issue 1 of the certificate. If we can go, please, to BBA 50178. And if we can begin on page 3. This begins, yes, this is the beginning of the chain. It's an email from Mr. Brian Martin. You can see from communities.dsi.gov.uk to you, copying in Guy Bampton and Nick Price. And the subject is safety concerns regarding BBA certificate 08452. And he says, "Dear John, I'm not sure we have met. I'm currently the official at DCLG responsible for Part B of the building regulations. It's come to my attention that the BBA certificate 08452-2008 included advice that the product in question satisfied paragraph 12.7 of volume 2 of approved document B. Paragraph 12.7 provides that insulation materials used in external walls should be materials of limited combustibility. It would appear, however, that the product in question is not a material of limited combustibility. I am also aware that certificate 08452 has recently been revised and that this reference has been removed. I am concerned that the original certificate may have been issued in error. As this is a serious safety matter, I would appreciate it if you could investigate and advise me of the outcome of your investigation as soon as possible. Could you please also acknowledge receipt of this email?" And then he said, "Best regards, Brian Martin." Now, can you help us? What was your reaction when you received this email?
I think I was on leave when this email was sent, and it was redirected to my colleague, John Denyer, who handled the immediate investigation in my absence. When I returned from leave, John and I discussed, and I responded from that point. So I wasn't aware of this, the receipt of this initial email at the time.
Okay, so when you did become aware of this email, when you returned from leave, what was your reaction to it?
I was concerned. Clearly, this was an issue I was previously unaware of. I was aware of Brian Martin as an experienced professional responsible for approved document B, and of course I was concerned that he had these issues.
Yes. Do you accept that Mr. Martin doesn't appear to have considered the possibility that the reference to 12.7 was in fact a reference to the exception for masonry in 12.7?
Well, at this point I wasn't really aware of the nature of his concern, but no, it doesn't mention masonry construction.
No, he's read it and he has assumed that the reference to paragraph 12.7 is stating that this product can be considered a material of limited combustibility, yes?
He's not stating that. He's asking us to explain the text of the certificate.
Well, he's saying very clearly in the second paragraph, isn't he? Paragraph 12.7 provides that insulation materials should be materials of limited combustibility. It would appear, however, that the product in question is not a material of limited combustibility. So he is concerned about the thrust of paragraph 12.7, yes?
Yes.
Did you agree when you read this that with Mr. Martin's view that this was a serious safety matter?
Without knowing the basis of his concerns, I couldn't draw a conclusion, but he had stated it is potentially serious safety matter. So yes, I was very concerned.
Well, can I ask it this way? Once you knew the basis of his concerns, did you agree with him that this was a serious safety matter?
I don't think I ever found out the basis of his concerns.
Sorry, I don't understand that answer. Aren't the basis for his concerns very clearly set out in this email?
I never had a conversation with Brian Martin on this subject. We twice offered to meet with MHCLG and they declined our invitation.
Are you saying that you didn't understand the basis of his concerns based on this email and a reading of amended issue 1 of the certificate?
I understood the question he was asking me, yes, and we responded. An explanation. I did not understand the background that had caused him to raise this concern.
I see. Let's look at your response to Mr. Martin. It comes 5 days later on the 16th of July. We can see it in the email above on page 2, timed at 12:14. We could go to that. Now, I'll read it to you in a moment, but can you remember, had you discussed Mr. Martin's email with any colleagues before you sent this response?
Yes.
5 days later on the 16th of July 2014.
Yes, as I've explained, my colleague John Denyer carried out an investigation, aided, I think, by Gayatri Ramkaran, and I believe the three of us discussed it. Certainly John and I discussed it.
So you discussed it with John Denyer, and you think with Miss Ramkaran, it's Miss, isn't it? Is that right?
Yes.
Yeah. So you think the three of you discussed it before you sent this email, is that correct?
I am sure I discussed it with John Denyer. I can't be sure about Gayatri.
And can you help us? What was the nature of those discussions? What did the three of you discuss?
The wording of the certificate, the basis for it, justification for it or otherwise, and consequences.
And what consequences did you discuss based on the wording of the certificate?
Was that certificate still valid? Was the wording still in place? Were there other certificates of the same type that had the same wording that were valid? How did the events come about? Who came up with the wording? And what was the likelihood of that wording occurring in future certificates?
I see. And as you've explained, and as you also tell us in your witness statement, you said that your colleague John Denyer conducted an initial investigation. Can you help us? What did Mr. Denyer's investigation consist of? What did he do?
It's difficult for me to recall. He certainly would have read the certificate, looked at the basis for the statement made, presumably discussed it with colleagues who had drafted it. I'm afraid I don't remember the full details.
Can you help us as to what his findings were? Because you tell us at paragraph 184, page 47 of your third witness statement, that your response to Brian Martin was guided by information generated by the investigation. Can you help us? What were his findings that investigation had generated?
That statement was open to interpretation and potentially misleading.
Right. If we go back to that email that you write to Mr. Martin, let's look at your response. So you say, Brian, and then you say, read that certificate, and you quote the number and the title. Thank you for your mail regarding the above certificate. The amendments made on 6th of April 2010 to certificate 084582 included a new reference to paragraph 12.7 of approved document B. This was not intended to imply that the product was of limited combustibility and, as you have observed, was removed in the subsequent reissue dated the 17th of December 2013. the reference to paragraph 12.7 seems to have been an unfortunate and rare oversight that would not escape the internal checks and measures that BBA currently operate. A review of other certificates has confirmed that this has not been reproduced elsewhere. Now, I just want to pause there. We've just been through your witness statement, and we just heard your evidence on the point, where you've told us that the reference to 12.7 of ADB was inserted into the certificate due to the potential use of the product in masonry cavity wall construction. And you've told us that the reference to 12.7 was only removed as a result of coincidental and wider changes in the formatting applying to all references to the building regulations and the guidance. So that's what you've told us in your statement and in your evidence. But here in the email we've been looking at, you tell Mr. Martin that the inclusion of 12.7 was an unfortunate and rare oversight, which was subsequently removed. Can you help us? Why do you tell him that in this email?
Well, firstly, if I said in my witness statement that this was inserted because it was intended to cover a masonry construction, I apologise, that wasn't the intention. That is the only way I can see that that statement would be correct. I think there is a difference.
Yes, I see.
In terms of the specific reference, it was removed as part of a policy. If that policy had not been in place, it would have been reviewed. And I think it would have been removed on the basis that it was potentially confusing. That judgment was not made because of the policy that overrode it. In terms of my statements to Brian Martin, I think it was included in error because it is potentially misleading. And that was, as I described there, unfortunate and I think a rare oversight.
I see. So I think you're telling us, is this right, that the inclusion of it was an unfortunate and rare oversight, and all you're doing in your statement is speculating about how that reference might potentially have been at least partly correct. Is that right?
Yes.
Why do you say in your email that it would not escape the internal checks and measures that the BBA were operating in July 2014? Can you help us with that?
Yes, at that point, we would not be making changes of this type by amendment. Amendments should only be for very straightforward and simple non-technical corrections to a certificate. For that reason, there was a lower level of checking and oversight applied to an amendment than would have been the case for a reissue of the certificate. In addition, since this amendment was instigated in 2010, we had put in place additional levels of checking and additional levels of management within the organisation, which meant it was significantly less likely that this type of oversight could recur.
I see. And what was the review of other certificates that you refer to in your email? You can see in the third paragraph down, you say a review of other certificates has confirmed that this has not been reproduced elsewhere.
We checked to see there were no other rain screen insulation certificates that would parallel K15 and in which we could have made the same mistake, and there wasn't.
What do you mean by no other rain screen installation certificates that would parallel K15? What do you mean by that?
Well, as I've tried to explain in this email, we have a system of leader certificates whereby any certificate of a given product type should have, as far as is technically possible, the same technical wording, so they are consistent and comparable. So we looked to check there were no other rain screen insulation certificates where we might expect to see this same wording.
I see. And who carried out that review?
either John Denyer or me. I can't remember.
I see. We'll come back to that in a moment, but can I just ask you, can you tell us why did you not mention the diagram 34 masonry exception to Brian Martin in this email? Can you explain that?
I think we had accepted that this wording was open to misinterpretation and was an error. I don't think there would have been any value in trying to qualify that. At the time I wrote this email, the certificate had been reissued with new wording. It was no longer current. We didn't understand the background and the nature of his concerns other than the email, which is why the BBA's chief executive and I offered to meet with Brian to discuss this to better understand his concerns. He chose not to take up that invitation, and we offered a second time, and again he chose not to meet with us.
Yes, I understand. But can you explain what is the value, as you've tried to do today and in your witness statement, what's the value of qualifying that statement now if that wasn't a position that you took with Mr. Martin back then?
Well, I think in my response to the questions of the inquiry, I've been dealing with the situation from 2008 up until mid-2017. This was in relation to a specific certificate that had only been in place for a matter of months and had since been reissued so that the wording was no longer current.
I see. Now, going back to this review of other certificates, when had that taken place? Was that between your return to the office and your response to Mr. Martin on the 16th of July 2014? Can you help us with that?
Yes, it would have been.
And how could you be certain that the error had not been reproduced elsewhere without a wider form of investigation?
There are a very limited number of certificates of this type. The BBA has records of all of those certificates. We identified them and we checked all of them. I think there was only one other at the time.
I see. Can we go now to BBA 404224? This is a series of internal BBA emails on this subject. If we start at the bottom of page 3, and Mr. Denyer's email to you and Miss Ramkaran, there on the 15th of July, at 9:40, we can see he writes, paragraph 12.7 of approved document B requires insulation above 18 metres to be of limited combustibility unless it is contained within a masonry cavity wall, complying with diagram 34. And then over the page to page 4. While the certificate contains a lot of subsections that are clearly taken from cavity wall insulation certificates, it may not have been the intention to imply that the use of the product within masonry cavity walls is within the scope of the certificate. I can't find anything on JobCon FS relating to the amendments made on the 6th of April 2010 and signed off by Chris Hunt. This may also be the first and only rain screen insulation board. And then he proposes a draft reply, and he sets out that draft reply to Mr. Martin, which essentially you adopt when you reply to Mr. Martin. Do you agree?
Yes.
And Mr. Denyer was at the time a senior scientist within the BBA. That's right, isn't it?
Yes.
If we move up the chain to the next email on page 3, we can see you send an email to Miss Ramkaran at 9:21 on the 16th of July 2014. And note the time, 16th of July 2014, 9:21. You say, Gaytree, I need to know urgently, i.e. today, whether this error has slipped into any other certificates of this type. Could you get someone to check this, please? Thanks and sorry for the lack of notice. Now, did the review of other certificates that you referred to in your email to Mr. Martin take place on the 16th of July between this email, 9:21, and when you sent your email to Mr. Martin, which was at 12:14 on the same day.
Clearly, it must have done. There was, I thought, only one other certificate of this type. From John Denye's email, it appears that this was the only certificate of this type. So the check would not have taken very long.
I see, but you say that that was nevertheless a thorough review, do you, taking place in around 3 hours?
If it was identified there was no other certificate of this type, it would not have taken very long to establish that.
Now, staying with this email chain, on page 2, we see that Ms. Ramkaran responds to your urgent message at 9:55, so about 35 minutes later on the same day. If we look at page 2. And she says, "Hi, John, as discussed, this was a first of its kind. That is a certificate for the insulation only in a cladding system without actually covering the cladding system, and hence perhaps required fire tests for fitness for purpose. We have offered Kingspan another contract for similar purpose, but in any case, it will follow the current version, which has the proper fire wording, as explained in the next paragraph. Having said that, if you recall, when we did the reissue last year, we did agree that the fire statement was indicating CWI when actually it was not. So the wording got changed, and any argument from the client was sent to Exover for their expertise opinion as attached." And then she goes on, "My thoughts. Bearing in mind that the original certificate was a first of its kind and hence would have been commented by technical, I do know the PM who worked on it originally used to be careless, and it's easy to blame him. However, other people have actually commented on the draft. Also, the revision was done by somebody who is normally very dependent on technical and seems unlikely would have included reference to 12.7 without checking first." Now, just can you help us? What did you understand her to mean when she refers to the proper fire wording in the 3rd and 4th lines of the first paragraph of that email? So she says, "But in any case, it will follow the current version, which has the proper fire wording, as explained in the next paragraph."
I would assume that means the wording in the second issue.
So wording that does not include the statement that it may be used in accordance with 12.7, yes?
Yes.
And what was meant by CWI in the second paragraph? Can you see the second paragraph, second line? She says, "Having said that, if you recall, when we did the reissue last year, we did agree that the fire statement was indicating CWI when actually it was not." Can you help us as to what that might mean?
Cavity wall insulation.
I see. So she's saying last year we did agree that the fire statement was indicating cavity wall insulation when actually it was not, yes?
Yes.
And is she right to say that the K15 certificate was a first of its kind in the first line of the first paragraph?
I believe it was, yes.
And also, and can we take it as well that the reference to PM under my thoughts in the second italicized line, she says, "I do know the PM who worked on it originally used to be careless." Do we take that that's project manager?
Yes.
And which project manager is Miss Ramkaran referring to there?
Well, it's not clear. Do you want me to speculate?
Well, what did you understand when you received this email? Who was she referring to when she said, "I do know the project manager who worked on it originally used to be careless"? What did you understand that to mean?
Probably George Lee.
Yes. And how would Miss Ramkaran know, this is at the 3rd line of that other people have commented on the draft? She says, "I do know that other people have actually commented on the draft."
I don't know. I don't know which draft she's referring to.
Yes, we don't have those or any version of this certificate with comments from others, nor do we know who might have commented on the draft. So you don't know either, no?
Sorry, no, I don't.
Did you carry out any further investigation into who might have commented on or checked the draft?
No.
Why not?
As far as I was aware, it was George Lee and Chris Hunt who had worked on the amendment. Neither of those individuals were still employed in a technical capacity by the BBA.
So that was the reason why you didn't carry out any further investigation into those individuals, yes?
Yes.
Yes, Mr. Chairman, I think that is an appropriate moment. Sorry that I've gone on a couple of minutes past 4:30. I'm doing well, and I anticipate tomorrow I would be around no more than 45 minutes an hour with this witness.
Right, thank you very much. Well,
We'll have to go into tomorrow.
yes. Well, there we are, Mr. Albon. I'm sorry we've got to ask you to come back tomorrow. I think not for too long, if that's any consolation. And I think you can expect to be away by lunchtime anyway. So we'll stop there. We'll continue, please, at 10 o'clock tomorrow. And once again, I must ask you not to discuss your evidence or anything relating to it with anyone else over the adjournment, all right?
Okay, understood.
Okay, thank you very much. Then we'll see you at 10 o'clock tomorrow, please.
Okay.
And that's the end of today's business. Thank you very much.